Hello. Our first video set out an introduction to the UK Government's commitment to ensure no diminution of certain rights, safeguards and equality protections as a result of Brexit. This commitment is made in Article 2 of the Windsor Framework. This video will look at how we should understand this commitment and how it should apply in practice. We do this by asking 4 questions. Firstly, does the right, safeguard or equality of opportunity protection fall within the relevant part of the Belfast Good Friday Agreement? Secondly, was the right, safeguard or equality of opportunity protection underpinned by EU law binding on the UK on or before the 31st of December 2020? Was it given effect in Northern Ireland law on or before the 31st of December 2020? Third, has there been a diminution in the right, safeguard or equality of opportunity protection on or after the 1st of January 2021? Fourth, would this diminution not have occurred had the UK remained in the EU? Is it as a result of Brexit? In other words, would it have been unlawful if the UK had remained in the EU? If the answer to each question is yes, then a breach of Article 2 of the Windsor Framework has been identified.
Let's break down what that means in practice. In the first instance, we must look to the Rights, Safeguards and Equality of Opportunity chapter of the Belfast Good Friday Agreement and identify the relevant right within that chapter. As noted in our earlier video, this chapter includes a non-exhaustive list of rights and a commitment to civil rights and religious liberties of everyone in the community. It also includes a commitment to the incorporation of the European Convention on Human Rights and a public sector equality duty, and it anticipated further work on a Bill of Rights for Northern Ireland. It is clear that the parties were making a broad commitment to human rights and equality. The next step is to look to the relevant EU law which underpins the right identified in the Belfast Good Friday Agreement and which applied in the UK before it left the EU. To do this, we must identify the relevant EU law, regulations and directives which applied, and we must also look to the case law of the European Court of Justice. Under the treaty, relevant provisions must be interpreted and applied in line with EU norms. For example, EU law must be interpreted in line with the EU Charter of Fundamental Rights and EU general principles such as the principles of proportionality and non-discrimination. It will also be important to identify how that EU law was given effect in Northern Ireland law before the UK left the EU. However, even if the UK was in breach of its EU obligations on 31st of December 2020, those provisions of EU law could still be relevant, provided they were capable of having direct effect. In other words, if they were unconditional, clear and precise enough to create enforceable rights. When we are looking at whether there has been a diminution or a reduction in the protection of rights, we need to bear in mind that this is an obligation of result. This means that Northern Ireland law can change over time. But this change should not bring about a lowering in the level of protection afforded to the right in question, either in terms of the content of the right itself or how that right is enforced and the remedies which are available for a breach of that right. The final question is whether the diminution is as a result of withdrawal, or in other words, would it have been unlawful for the UK to have made this change when it was an EU member state? If the answer to all these questions is yes, then a breach of Article 2 of the Windsor Framework has been identified. However, if the UK could have made this change when in the EU, even if it results in a lowering of the protection of rights, then no breach is identified.
To understand what this means in practice, we will look at the UK Government's proposals for addressing the legacy of the Troubles. Neither the Northern Ireland Assembly nor the Executive can act in a way that is incompatible with Article 2 of the Windsor Framework. A similar restriction applies to laws made by the Westminster Parliament. Section 7A of the EU Withdrawal Act 2018 brings the withdrawal agreement into UK law and means that domestic laws must comply with it. The Commission is concerned that the Northern Ireland Troubles Legacy and Reconciliation Bill is not human rights compliant. It creates an immunity scheme for gross abuses of human rights, specifically the right to life and the prohibition of torture and inhuman treatment, which violates the European Convention on Human Rights. The Commission is also of the view that it may breach Windsor Framework Article 2. The procedures for granting immunity are of particular concern. Does the right, safeguard or equality of opportunity protection fall within the relevant part of the Belfast Good Friday Agreement? Yes, the Belfast Good Friday Agreement provides that victims have a right to remember as well as to contribute to a changed society. The UK Government has recognised that victims' rights fall within the scope of the relevant chapter of the agreement. Was the right, safeguard or equality of opportunity protection underpinned by EU law binding on the UK before the 31st of December 2020? Yes, the EU Victim Directive established minimum standards on the rights of and support for victims of crime and ensures they are recognised and that they receive proper protection, support and access to justice. Has there been a diminution in the right, safeguard or equality of opportunity protection on or after the 1st of January 2021? Yes, Articles 6 and 11 of the Directive provide for victims to have the right to a review of a decision not to prosecute. Victims also have the right to receive information about criminal proceedings related to their complaint. This includes any decision not to proceed with or to end an investigation, or a decision not to prosecute the offender. The bill does not require such information to be provided to victims or their family members. Neither does it provide for a victim to have a right to appeal a decision on immunity. The bill does not appear to comply with the directive, as a decision to grant immunity is tantamount to a decision not to prosecute. Is the diminution as a result of UK withdrawal from the EU? Would it have been unlawful for the UK to have made this change when it was an EU member state? Yes. The UK was bound to comply with the terms of the EU Victims Directive prior to Brexit. It is the Commission's view that the provisions on immunity and restrictions on criminal enforcement action in the Legacy Bill may diminish the rights of victims in breach of Windsor Framework Article 2.
Windsor Framework Article 2 is an important safeguard which upholds human rights and equality standards, which are at risk of being diminished following the UK withdrawal from the EU. However, it is limited in its scope and application. It is not a substitute for a comprehensive human rights and equality framework, as would be provided, for example, by a Northern Ireland Bill of Rights. The Belfast Good Friday Agreement requires that there is at least an equivalent level of protection of rights in Ireland as in Northern Ireland. The Commissions take the view that long-term North-South equivalence is important. Before the UK left the European Union, EU law played an important role in ensuring human rights and equality were protected in Northern Ireland. Article 2 of the Windsor Framework is only one strand of the work of the Commissions, which are mandated to protect and promote human rights and equality in Northern Ireland. Northern Ireland already has gaps in human rights protection as compared with Ireland and Great Britain. The Commissions are therefore recommending voluntary alignment of Northern Ireland law with progressive developments in EU law. Thank you for taking time to watch this video. The next video will examine more closely what EU laws we have identified so far as underpinning the rights and safeguards in the Belfast Good Friday Agreement.